I'm going to talk about special reasons. Special reasons are circumstances under which a court might consider not imposing a driving disqualification. Special reasons are normally used in connection with offences relating to drink driving. Now, drink driving is an offence under Section 5 of the Road Traffic Act 1988, and drink driving carries a minimum disqualification period of 12 months. It can be more than 12 months, but 12 months is the minimum. For an individual who has been convicted for a second time within 10 years of an offence of drink driving under Section 5 of the Road Traffic Act 1988, the minimum disqualification period is then 3 years. So under the Road Traffic Offenders Act 1988, Section 34, the law states that for matters that carry an obligatory disqualification period, a court may consider special reasons either to reduce the disqualification period or not to disqualify at all. But the special reasons have to relate to the offence itself rather than to the individual. What that means is this: if an individual pleads guilty or is found guilty of drink driving under Section 5 of the Road Traffic Act 1988, it's not possible for them to ask the court not to disqualify them for driving because, for example, they have a member of their family who relies upon them to drive on their behalf. That would be a personal reason, and that is not a special reason under the Road Traffic Offenders Act 1988. A special reason under the Road Traffic Offenders Act 1988, Section 34, has to relate to the circumstances of the offence itself. It can't be a defence. The individual still has to be technically guilty of the offence, but it must be something that can be used as mitigation towards the offence, and it must be something that the court should reasonably take into consideration. So, for example, a special reason might be if the individual did drive with excess alcohol in their system, but it was a genuine emergency. Or another example might be if the individual did drive with excess alcohol in their system, but they only drove a very short distance. For example, a distance measured in yards rather than in miles. Or it might be if an individual drove because their drink had been spiked and they didn't realise that they were over the prescribed limit. So in those three examples that I've given, an emergency, a very short distance, or a drink that had been spiked, in each of those three examples, that concerns the offence itself, the circumstances of the offence itself. It doesn't concern the individual's personal circumstances. So special reasons are allowed to try to argue in front of a court why an individual who has been convicted should not be disqualified or should be disqualified for less period of time in relation to matters that the court should reasonably take into account that are not a defence but are rather a mitigation and explanation as to the circumstances why they drove. So for example, if it was an individual's child who had to be rushed to hospital in an emergency, that might be a special reason why a court might decide, for special reasons in those particular circumstances, not to impose an obligatory disqualification period.